Okay, I'm live now. And we're going to finish this module 6, even though it's still a lot to cover. Very important section on not on breach yet, on excuse of performance. So, excuse of condition by hindrance or failure to cooperate. A party having a duty of performance that is subject to a condition that is a party protected by the condition prevents the condition from occurring. The condition will be excused. Prevention is wrongful, meaning the other party would have reasonably contemplated or assumed the risk of this type of conduct. Excuse of condition by waiver or estoppel. One having the benefit of a condition under the contract may indicate by words or conduct that they wish not to insist that the condition being met. Consideration is required for valid waiver of a condition. And estoppel waive. Whenever a party indicates they are waiving a condition before it is to happen, or they are waiving some performance before it is to be rendered, and the person addressed detrimentally relies on the waiver, the courts will hold that this to be binding estoppel waiver. Note, however, that the promise to waive a condition may be restricted at any time before the other party has changed their position to their detriment. Election waiver. When a condition doesn't occur or a duty to performance is broken, the beneficiary of the condition or duty must make an election. They may terminate their liability or to continue under the contract. If they choose to continue, they will be deemed to have waived the condition or duty. An election waiver requires neither consideration nor estoppel, although estoppel elements are often present. Note that the election waiver cannot be withdrawn even if the other party has not relied on it. Conditions that will be waived. If no consideration is given for the waiver, the condition must be ancillary or collateral to the main subject and purpose of the contract for the waiver to be effective. In other words, you cannot waive entitlement to the entire or entitlement to the entire or substantially entire return performance. Waiver and installment contracts. In an installment contract, if a waiver isn't, and this is waiver of a condition, by the way, in case we forgot. If a waiver isn't supported by consideration, the beneficiary of the waived condition can insist on strict compliance with the terms of the contract for future installments, so long as there has been no detrimental reliance on the waiver by giving notice that he is revoking the waiver. Right to damages for failure of condition. It is important to note that the waiver serves only the right to treat the failure of the condition as a total breach, excusing counterperformance. However, the waiving party does not thereby waive her right to damages. See, next section, excuse of condition by actual breach. An actual breach of the contract when performance is due will arise or excuse the duty of counterperformance. Note, however, page 90, note, however, that the counterperformance will be excused by common law only. If the breach is material, a minor breach may suspend the duty but won't excuse it. Excuse of condition by anticipatory repudiation. This is the next section. Anticipatory repudiation occurs if the promisor, prior to the time set for performance of the promise, indicates that they won't perform when the time comes. If the requirements set forth below are met, the anticipatory repudiation will serve to excuse conditions. So, executor, I'm going to read the headers. No, I'm going to read everything. Executory bilateral contract requirement. Anticipatory repudiation applies only if there is bilateral contract with executive underperformed, in other words, duties on both sides. Anticipatory repudiation must be unequivocal, and anticipatory repudiation stems from the words or conduct of the promisor unequivocally indicating that he cannot or will not perform when the time comes. Effect of anticipatory repudiation. In the case of an anticipatory repudiation, the non-repudiating party has 4 alternatives. Treat the anticipatory repudiation as a total repudiation and sue immediately. Suspend their own performance and wait to sue until the performance date. Treat the repudiation as an offer to rescind and treat the contract as discharged, or ignore the repudiation, urge the promisor to perform, but note that by urging the promisor to perform, the non-repudiating party is not waiving the repudiation. They can still sue for breach and are excused from performing unless the promisor retracts the repudiation. Retraction of repudiation. A repudiating party may at any time before the next performance is due withdraw their repudiation unless the other party has canceled, materially changed their position in reliance on the repudiation, or otherwise indicated that they consider the repudiation final. Withdrawal of the repudiation may be any manner that clearly indicates the intention to perform, but must include any assurances reasonably demonstrated. Next section, excuse of condition by prospective inability or unwillingness to learn. Prospective failure to confirm about all right, I kind of lost my spot because I'm like totally falling asleep here. And yet I have like more than 20 pages left. So I'm going to pick this up. Excuse of condition by prospective inability or unwillingness to perform. Prospective failures of condition occurs when a party has reasonable grounds to believe that the other party will be unable or unwilling to perform when performance is due, distinguishing from actual and anticipatory repudiation. Prospective inability or unwillingness to perform is not an anticipatory repudiation because such a repudiation must be unequivocal, whereas prospective failure to perform involves conduct or words that merely raise doubts that the party will perform. Effect of prospective failure. The effect of prospective failure is to allow the innocent party to suspend further performance on their side until they receive adequate assurances that performance will be forthcoming. If the other party fails to provide adequate assurances, the innocent party may be excused from their own performance and may treat the failure to provide assurances as a repudiation. Remember, that's adequate assurances. Adequate. Next, page 92, maybe. Retraction of repudiation. So yet another R word. Not a rescission. Not a reformation. This is a retraction. As with anticipatory repudiation, retraction is impossible for the defaulting party if the defaulting party regains their ability or willingness to perform. However, this fact must be communicated to the innocent party in order to be effective. Excuse of condition by narrative performance. Generally, the condition of completed performance may be excused if the party has rendered substantial performance. In this case, the other party's duty of counter-performance becomes absolute. It should be noted, however, that courts generally apply this doctrine only if a constructive implied in-law condition is involved. They won't apply it if there is an express condition for fear that this would defeat the express intent of the parties. Substantial performance arises if breach is minor. The rules for determining substantially the substantiality of performance are the same as those for determining materiality of breach. Applicable where breach willful. Inapplicable where breach was willful. Most courts won't apply a substantial performance doctrine if the breach was willful. And damage is offset. Even though the party who has substantial performance is able to enforce the contract, the other party will be able to mitigate by deducing damages suffered due to the fiduciary's incomplete performance. That's a lot of information. Now we're going to take it from the other party to mitigate by deducting the damages suffered due to my bloody hand. I'm kidding. Generally inapplicable to contracts for the sale of goods. The doctrine of substantial performance doesn't apply to contracts for the sale of goods by just read this one again. The doctrine of substantial performance doesn't apply to contracts for the sale of goods because perfect tender is generally required. Excuse of confidentiality by divisibility of contract. This is probably where I lost my spot. If a contract is divisible and the party performs one of the units of the contract, they are entitled to agreed on equivalent for that unit, even if they fail to perform on the other's units, is that it isn't a condition for me to be performed. However, the other party must have a a cause of action for failure to perform on the other units and may withhold their counter performance for those units. What is a divisible contract? So there's two in writing, and the performance of each party is divided into two or more parts of each one, and the number of parts due from each party is the exam numbers on the situation of the corresponding from the other party, meaning each performance is the quid pro quo of another. And then surprisingly, last section on this page 93 is the sale of goods installment contracts. Like common law, Article 2 assumes that the contract, like the common law state, unless it authorizes deliveries in several lots, which cause the conduct. The contract is called an installment. What installment? Maybe that's just a period because it won't scroll down. Contract. In installment contracts, the price, it can be apportioned, may be deemed for each lot unless a contrary form appears. And lastly, my one-on-one has the absolute duty to perform bid discharge. Has has the absolute duty to perform been discharged. Once it is determined that a party is under an immediate duty to perform, the duty to perform must be discharged. Discharge by performance or tender of performance. The most obvious way to discharge a contractual duty is, of course, by full and complete performance. Good faith tender of performance may be made in accordance with contractual terms. Also discharge contractual duties. Discharge by occurrence of condition subsequent. The occurrence of a condition subsequent will serve to discharge contractual duties. And discharge by illegality, if the subject matter of the contract has become illegal due to subsequently enacted law or other government act, performance may be discharged. This is often referred to as supervening illegality. Note, if the illegality existed at the time the agreement was made, no contract was formed because of that inquiry. Discharge of rescission. Rescission will serve to discharge contractual duties. Rescission may be either mutual or lateral. Mutual rescission, the contract may be discharged by express agreement between the parties to rescind. The agreement to rescind is itself a binding contract supported by consideration, namely the giving up by each party of the contract. Each party or their right to counter performance from the other. Contract must be executory. For a contract to be effectively discharged by rescission, the duties must be executory on both sides. Unilateral contracts. If the contract is unilateral, meaning only one party owes a specific duty, a contract to mutually rescind, where one party still has duty to perform, will be ineffective. For an ineffective rescission in a unilateral contract situation where the performance, where the offeree has already performed, the rescission promise must be supported by one or more of the following: an offer of new consideration by the new party, elements of promissory estoppel, meaning detrimental reliance, and maintenance of an intent by the original officer to make a gift of the obligation save them. Owed them. Partial performance. Bilateral contracts and mutual agreement to rescind will usually be enforced. On page 96 now. When a bilateral contract has been partially performed, whether the party who has partially performed will be entitled to compensation in terms of the rescission agreement. And in this next section, you'll see formalities and contracts involving third-party rights. In formalities, mutual rescission may be made orally. This is so even though the contract to be rescinded expressly states that it can be rescinded only by written documentation unless the subject matter of the contract to be rescinded falls within the statute of frauds, for example. Transfer of land or the contract is for the sale of goods. Article 2 requires a written rescission or modification if the original contract to be rescinded or modified expressly requires a written rescission. Contracts involving third-party beneficiary rights. If the rights of third-party beneficiaries have already vested, the contract may not be discharged by mutual rescission. And unilateral rescission is the last thing before the next subsection. So unilateral rescission requests when one of the parties to the contract decides or desires to rescind it, but the other party desires that the contract be performed according to its terms. For unilateral rescission to be requested, the party The party retiring or desiring the rescission must have adequate legal grounds. Most common among these are mistake, misrepresentation, duress, and failure of consideration. If the non-asserting party refuses to voluntarily grant rescission, the other party may file an action in equity to obtain it. And I'm going to take a break, even though we're at partial discharge by modification of contract on page 96. There's probably like 20 more pages left. And I'm crushing pretty hard, crushing and burning.